Well, Daniel Bwala joins us. He's also a legal practitioner and an adjunct lecturer in Nigerian Law School from our studios in Abuja. Morning. Thank you for joining us today. Let's get straight to the crux of this matter. This judgment many disagree with. What do you think of? You think that, well, having looked at the issues before them and then handed that judgment, also citing the Electoral Act, they were in the right to have given it?
Judgment of elections raises quite issues, even though with the learners that go for us, a perspective haven't the judgment itself. However, facts are in the public domain, which so far have not disproved or contested, which are that number one, the judgment of the tribunal nullified the election of Darius, and number two, the election tribunal also declared Al-Hassan as the winner of that election. Now, what the Court of Appeal may be interested in looking at, if the matter is presented before it, are a number of issues. One is the provision of Section 140 sub 2, whether the tribunal in delivering the judgment actually considered that provision as was canvassed by the respondent. And if it did, whether the tribunal was right to have considered that provision and then go ahead still to give the election decision to Al-Hassan. The other issue is the testimony of INEC, whether the testimony of INEC should be believed in the first place, because in determining the veracity of a testimony, the testifier's character and the testimony must be in unison. And it is the character of INEC to defend every election, because INEC, when the nomination name was submitted to INEC, INEC had every reason under the law to reject the name if it did not comply with the provisions of the Electoral Act, but INEC went ahead and accepted that. So that is one of the issues that the Court of Appeal will look at. Then on another issue is whether the court was right in rejecting the testimony of PDP when it led evidence that the reason for the shifting of the primaries to Abuja was occasioned by insecurity, especially having regard to the recent decision of the Court of Appeal in Rivers' case, when the Court of Appeal held that the doctrine of necessity permits that the election tribunal should sit in Abuja rather than in Rivers State, and whether the tribunal was right in rejecting that. And if it did, then whether the tribunal sitting in Abuja itself is also challengeable in law, because the tribunal then ought to also sit in Taraba State. Now, the issue of whether the matter is pre-election or post-election, I do not want to delve much on it, because it's like a hybrid. You can determine the matter as a pre-election matter, but if you fail to do it and it comes to the court, the election tribunal, then it must fall under one of the grounds, and it fell under Section 138, subsection 1, either A or B. Now, the proper relief that the court granted to Al-Hassan would have been Section 138 sub 1C, that Darius did not score the highest votes. But it seemed that the tribunal delivered the judgment relying on the grounds that was canvassed, looking at Section 138A and B, non-compliance, and then lack of qualification. So the Court of Appeal will be interested in looking at all of this.
And it's also very interesting looking at this grounds of petition. But then when Moyashere was talking about some of these cases, he raised issues about qualification, and even if they were to give or rerun, he suggests that the PDP may not have a candidate in that rerun. How does that work?
That is another issue for the court to determine, because every conversation regarding the nomination of a candidate, first of all, is a matter that is a matter that should be determined by the High Court, and in which case the person to challenge it may not have been Al-Hassan in the first place, will have been a member of PDP who is challenging the nomination of that candidate. If the court nullifies this election and gives a date, for example, under which they are expected to conduct election, then at that point, probably either of the party can go to the High Court to ask whether or not Darius was qualified. And like I said earlier, the doctrine of necessity, because the crux of the matter is the tribunal rejected the evidence and ruled that there was non-compliance with the provisions of Section 87, which is to wit that the primaries was not conducted in Taraba, it was conducted in Abuja, and then secondly, that the notice given to INEC was quite outside of the time. Now, don't forget the provision of the law that also states that governorship election tribunal should sit in various states. That is a fact stated in the law. But the Court of Appeal held that under doctrine of necessity, it was proper for you to have it in Abuja. So these are also matters that when they want to, when the High Court will look at whether or not the candidate in the first place was qualified to contest. And within the period, whatever judgment the High Court comes up with will form part of the issues that might be looked at in the election proper.
All right, let me ask you to explain this a little bit for us, because, I mean, Moyo should have also spoken about it, but it skipped me. Section, that should be 87(9) of the Electoral Act, still touching on the testimony of INEC, but here it says that where a political party fails to comply with the provisions of this act in conduct of its primaries, its candidates for election shall not be included in the election for the particular position in issue. But he says that INEC's hands were tied, that they cannot reject any candidate. But looking at this, what does that say?
That provision you just read is quite clear and unambiguous. When the provision said it shall not be included, who includes? Who published the name of the candidate? Who returns the candidate after election? It's INEC. INEC is within its power to refuse, and then the aggrieved party can go to the court to ask whether INEC was right to have refused including the name of that candidate. And that actually reflects on the point I was saying earlier, that the testimony of a testifier must be consistent with the character. It is in the character of INEC after the election to defend the outcome of election, because the INEC is the one empowered by law to conduct election and declare the winner. So that provision that you just read says it shall not, and there is a decision, plethora of decisions of the Supreme Court, that the word shall is mandatory. So who is it that will stop inclusion of that person? Is it not INEC? INEC failed to do that. So if INEC accepted the name, published the name, returned the candidate as a winner, should the court believe the testimony of INEC that there was no primary in the first place? That's another issue. Now, even the issue of Section 140 sub 2, one issue I want to point out is, one point I want to stress is, number one, whether the court itself, when presented with the provision of Section 142, actually considered it in its judgment, because that will form part of the appeal. If the court considers Section 140 and ruled that that provision of the Constitution is unconstitutional, which is what we doubt whether it did, but there is a conversation going around that there is a ruling of the Federal High Court or decision of the Federal High Court striking down Section 140 sub 2. Now, even the decision of the Federal High Court is matter that should be tested at the Court of Appeal, because the Federal High Court decision striking down Section 140 sub 2, they said because that provision is inconsistent with the Constitution and therefore it usurps the power of the court. Now, I do not know whether that provision is inconsistent with the provision of the Constitution, because according to the report we heard, that the Federal High Court relied on Section 6 that touches on the power of the court to determine matters, interpretation of the law, and Section 285 in relation to election tribunal, governorship election tribunal, that the tribunal is the one to the exclusion of all other courts with the jurisdiction to determine. Now, if the tribunal is empowered by the Constitution to determine whether or not a candidate is the winner, that governorship election tribunal is also guided by a law that regulates the conduct of election petition, which is the Electoral Act. And the wordings of Section 140 sub 2 is quite clear and unambiguous. And there are decisions of court replayed that where the wordings of a statute, where the construction of a statute is clear and unambiguous, the court does not have the latitude to go on a voyage. The court must give its ordinary meaning, regardless of whether the result makes sense or not. So, and that is the provision of the Electoral Act. So it will be interesting to know whether the tribunal considered that provision. And if the tribunal refused to consider that provision in delivering the judgment, it will also be interesting to look at whether the Court of Appeal will look at whether or not the tribunal in the first place ought to consider. Because when you present an issue before the tribunal must rule on that issue.
All right.